Good afternoon again. Hope all of you had a great lunch and are back for the presentation in a really enthusiastic manner. We are back for a presentation session on recognition of right to repair as a consumer right and sustainable consumerism, the session 3. By way of introduction, I am Satyar, the moderator for this session, assisted by Anshuman and Arman. Earlier, we had a great opening session addressed by Professor Dr. Ashokar Patil, Ms. Nidhi Khare, and Professor Dr. C. Rajashekhar. This session, however, is different and will be judged by Mr. Jijimon B.A., Associate Professor, and Ms. Sarda Shinde, who is again Assistant Professor for NLSIU Bangalore. By way of elaborate introduction, Mr. Jijimon B.S., the first presiding judge for this session, he was an Associate Professor and founder head of the department at Dharmshastra National Law University, Jabalpur. He has 14 years of teaching and research experience in different institutions like Rajiv Gandhi National Law University, Punjab Patiala, School of Law, Christ University Bangalore, CMR Law School Bangalore, and here he was also associated with us here, National Law School of India University Bangalore. From 2012 to 2017, he was associated with Padma Bhushan Professor N.R. Madhav Menon in successfully organizing sorry, professional development training programs for lawyers and law teachers in various parts of India under the banner of continuing legal education. He has also participated in and organized many international and national moot court competitions and seminars. He was the principal investigator in Pan India project for different states. Now he has also presented paper and has been actively participated in many international and national training programs, workshops, and seminars. His area of interest is ADR, that is Alternate Dispute Resolution System, consumer protection, tort law, and human rights law. He has published a number of articles in journals and book of repute. He has also visited countries like Sri Lanka, UK, Turkey, Hong Kong to present paper on various topics of law and has been involved in spreading uh, awareness about the law itself. He's also the joint secretary of Menon Institute of Legal Advocacy Training and a member in a number of organizations like the Commonwealth Legal Education Association Asia India chapter, Forum of South Asian Clinical Law Teachers, Goa, and Global Alliance for Justice Education USA. I welcome you, sir, in this session on behalf of CLAP team and hope that we could learn a lot from your vast experience and knowledge. Now, moving on. Yes, sir, please. Okay. Yes, sir, if you would like to add something.
Thank you, Srivastava, Mr. Srivastava, for that warm welcome.
Yeah. Thank you so much, sir, and welcome again. Now, moving on to the second judge for this session, who is Ms. Sarda Shinde. She's a law graduate from the University College of Law, Dharwad, with first rank distinction and 2 gold medals. After practicing before the High Court of Karnataka for almost a year, she pursued LLM from the National Law School of India, University, Bangalore. She also joined KSLU as assistant professor in 2013 and has been associated with us, National Law School of India University, as an assistant professor of law from 2021. She is awarded the prestigious Dr. D.C. Memorial Fellowship at the Center of International Studies, Department of Politics and International Studies, Cambridge University. She has also published articles in various journals. In addition, she has delivered special lectures on topics like consumer law, administrative law, ADR, that is alternate dispute resolution, insurance law, and contract law. Currently, she is teaching family law and ADR at NLSIU. She is also pursuing a PhD from Karnataka State Law University in arbitration. We welcome you, ma'am, and are looking really forward to your deep insight and valuable feedback. Uh,
Thank you, Siddharth.
we again welcome you.
Satyarth.
No problem. That's good. So, moving on to the presenters for this session, I would also like to briefly introduce them. Mr. Gaurav Pathak. Mr. Gaurav Pathak is an LLM candidate at European Legal Informatics Study Program at the Faculty of Law at Leibniz University, Hanover. As a part of EULISP, he studied for a semester at Kyushu University, Japan. Earlier, he graduated with a BA LLB honors from Dr. Ram Manohar Lohia National Law University, Lucknow, India in 2016. Therefore, he worked at New Delhi-based law firm for over 5 years. Along with him, we have Ms. Gaurangi Kapoor. Ms. Gaurangi Kapoor is a legal researcher in the field of intellectual property law. She has an LLM in IPR and tech law from Jindal Global Law School, Sonipat. Earlier, she has graduated from BLLB from Dr. Ram Manohar Lohia, National Law University, Lucknow. Now, they will be presenting a paper titled Suggested Framework for the Right to Repair in India. Moving on, we have the second presenter, Chandrasekhar V. Pillai, who is an Mr. Chandrasekhar V. Pillai is an advocate enrolled in the Bar Council of Kerala. He graduated with PLLB degree from School of Law, Christ, Bangalore. He has published several papers and attended legal conferences thereafter. We also have Ms. Aishwarya Lakshmi VM, who is also a lawyer and a company secretary, CS as we know it. She completed her BBA LLB honors from School of Excellence in Law, Tamil Nadu, Dr. Ambedkar Law University, ACS from the Institute of Company Secretaries of India, and PGD FSL from Nalsar, Hyderabad. Their paper is titled as Repair or Replace Electronic Equipment, the Consumer's Dilemma and the Seller's Leverage. Now, moving forward, we have Dr. Ashwini Dalal. Over 18 years of law experience in various law areas. He has done LLM in labor, capital, and law, specialized in industrial adjudication, conciliation, and mediation, PhD in crime victim compensation, participated in various workshops and training programs, published articles on different law areas, and actively involved in Lok Adalat and various law and social workshops and seminars. And she would be presenting on recognition of right to repair as consumer right, a step ahead for minimizing waste. Sashikant Saurabh. Now we would be moving to him. Mr. Sashikant Saurabh, he is the author of the article that he would be presenting, that is E-Waste and Right to Repair, a step towards sustainable consumerism. He is working at Symbiosis Law School, Hyderabad as assistant professor of law. He is having teaching experience of 3 years approximately. Now, these were the introduction of all the presenters as well as the judges present in the session. Before moving on to the actual session, I would like to just glance over some housekeeping rules here. The judges are the presiding authority for the presentation. The presentation would be for 15 minutes, and our only role as moderator or student coordinator would be to intimate the time that is left. We will inform everyone on the chat when 10 minutes and again when 13 minutes have passed. Ideally, the presenter ought to start concluding the session about this time mark. 15 minutes is the hard limit for everyone, but on the discretion of judges, it could be extended. But again, after 16 or 17 minutes, we would humbly intervene and request the presenter to stop if the judges are amicable to it. Meanwhile, no question from audience is allowed. The judges may put forth question to the presenter that had to be answered succinctly, because everything would be included in the 15-minute hard limit. When the session ends, there would be a session ends means if all the presenters have presented, there would be a Q&A session, and the modalities of it would be explained before the session. I would be there. After the Q&A session, there would be a feedback round, which would be presided again by both the judges. I hope everyone is clear on that. If somebody has any doubt, please feel free to raise it right now. So I will take it as a no doubt. So moving forward, first of all, we wish you all the best for the session, and all of us are looking forward to deep insights from your side. Are the judges ready to preside over the session, or they have to add anything?
We can start.
Yeah, we can start.
Okay, thank you so much. So as scheduled, we have the first presenter, that is Mr. Gaurav Pathak and Ms. Gaurangi Kapoor, who will be presenting on suggested framework for the right to repair in India. I would like them to please unmute them and please start with their presentation. We would be starting the time as soon as they say yes.
Good afternoon, everyone. My name is Gaurav. I hope I'm visible and audible, and my presentation is visible as well. Thank you so much. The title of my article is Suggested Framework for the Right to Repair in India. And the right to repair framework is fairly new in India, is yet to be made. The Department of Consumer Affairs made a committee in July this year. The committee is headed by the additional secretary, who was also part of this conference in the earlier session. And it includes people from all facets of social life, be it former judges, chairman of consumer commissions, academicians, consumer rights activists, consumer organizations, and all sorts. The committee has tentatively identified certain categories or certain sectors in which it wants to have the right to repair framework. But this categorization or identification is only tentative in nature because the committee is yet to decide on this. We got this information through an RTI application that we had made earlier, and it was told that the committee has not finalized anything with respect to the right to repair framework, and all these are initial deliberations that are currently going on. Also available through the RTA application was the information that the committee was to submit its recommendations within 6 weeks. Unfortunately, that time has elapsed, but we are hopeful that the committee would be able to finish its work fast and also consider the suggestions that we make during this conference and come up with the right to repair framework. Essentially, the right to repair is a right given to the consumer to get their equipment repaired through an independent repairer, or have the ability, that is the tools and information, to repair the equipment themselves. But this right is not such an easy task, as it involves different legal spheres that interact with this right, and we'll be discussing a few of them in my presentation. The first legal aspect that impacts the right to repair is of intellectual property. Now, any sophisticated equipment that you purchase comes with a manual, a repair manual, which is a literary work and is protected by copyright. It cannot be freely circulated all around. Most likely, the independent repairers do not have access to that repair manual through legal means. So therefore, the first barrier that comes in repairing any sophisticated equipment is the lack of availability of the repair manual. Now, as we have seen, all the devices are getting smarter or becoming smart devices. These devices have an inherent component of copyright, of software, which is also protected by copyright. With age, like with time, these softwares are being protected by digital rights management tools. So for example, if you have an HP printer and you want to replace its cartridge by, let's say, non-genuine cartridge, you will not be able to do so because the printer will reject that equipment, that cartridge. So therefore, DRM protections are making it more difficult to repair sophisticated devices. Under the literary work or under the copyright regime, there exists an exception of fair use, but unfortunately, that is not applicable to DRM as of now. Now, most of these equipment that we use are very sophisticated machines. They have certain novelty and are also protected by patent laws. The patent could be on the overall machines or different components that are used within the machines. Now, all the intellectual property regime allows the owner of the intellectual property to stop illegal spreading, importation, sale of intellectual property that is protected. So therefore, by virtue of patents, it becomes very difficult for independent repairers to get access to those tools through which they can repair, or access to the parts which are needed to repair the product. This has led to the aspect of cannibalization in India. That is, if you go to a mobile phone repairer and they want to use, let us say, a part that will be used to repair your camera, and they do not have it through the official channels, they will use another phone which perhaps was defective on another front, and you use part of that phone's camera to repair your phone. This cannibalization is not a very effective method to utilize all the resources that are present in an equipment. This is leading to generation of e-waste, as most of the other materials get discarded. And companies are also increasing DRM. So there was an episode of Apple in which people who got their iPhone screen repaired from independent repair shops got a message few days down the line saying that the phones were not working or will not be working because they were not repaired at the authorized shop. So companies and manufacturers have evolved technologically to desist consumers from getting their equipment repaired from independent repairers. Design law also comes into the picture. In my paper, I have detailed that how automotive companies and mobile phone companies have hundreds of designs over the parts that are used inside the equipment. And this, similarly to the patent law, acts as a hindrance in getting products repaired. But in all of this intellectual property scenario, I think there needs to be a realization that intellectual property goal is the overall benefit of society. Many scholars have argued that repairing is a transformative use, and therefore the barriers imposed by intellectual property should not be put onto the repair framework. And I also believe that we have to see overall societal benefit while taking care of the intellectual property aspect that the IP owners have, while also ensuring that the consumers have an equal hand in getting their devices repaired. There is a lot of geographical scarcity as well, which in turn brings the antitrust angle into this, or the anti-competition law angle into this. For example, there's not even a single Apple repair shop, authorized Apple repair shop in the entire Andaman and Nicobar Islands. Now, one may say that it is a very far off area. It might not be feasible to have a shop there. But of course, the devices are being sold there. And once devices are being sold, it is a genuine expectation that the repair should also be available. And therefore, this aspect of abuse of dominant position should also be looked into while enacting the whole right to repair framework. E-waste is a huge concern in our country today. Our landfills are full and waste is not segregated. E-waste is highly toxic and it is harmful to the environment. It is expected to grow enormously by 2030 and even beyond. India fortunately has e-waste management rules, but unfortunately, they are rarely being followed. We have the principle of extended producer responsibility. That is, if you have a Dell or an HP or an Apple manufacturing a device, they also have the duty to collect those devices once they are at their end of life. I think the companies need to have certain responsibility in this regard, and that responsibility needs to be enforced so that these rules are put into practice and just do not remain on the statute book. In the paper, we have compared the right to repair situation in different countries, and we use them to suggest the framework for India. For example, France has a repairability index in which devices are rated on 1 to 10 as to how much repairable they are. The United Kingdom also has the regulations in which it has identified certain equipment which should be repaired and should have a certain minimum life. Australia has many independent repair cafes and also a scheme for repairing motor vehicles. The US is interestingly very talked about when it comes to right to repair. The president of the United States has signed an executive order with respect to right to repair. The Federal Trade Commission is looking into it. There is one right to repair law which has been adopted by the vehicle industry across the United States. It's the Massachusetts Motor Vehicle Owners Right to Repair Act, and consumers can get their vehicles repaired all across the United States. New York has recently also passed a law on the right to repair. The rest of the states are a work in progress. The European Union is also working on the right to repair. It has proposed a framework for the right to repair. Apart from this, there are eco-design directives and also other laws within the member states which want companies to be more sustainable and the consumers to have more rights. We suggest a framework for the right to repair in India because repair is costly, because repair is needed. And the Prime Minister also launched the LIFE scheme in which it's talked about sustainable living. The right to repair framework in India should have these components. That is, there should be available information, tools, and parts that are required to repair the product. And these should be available on fair and reasonable terms. Secondly, it needs to be ensured that the manufacturers do not use digital locks to brick the devices in case a consumer gets it repaired from an independent repairer. Thirdly, the right to repair framework needs to identify the sectors in which such a right is sought to be needed or the government wants such a right to exist. And fourthly, we need to identify the conditions in which the right to repair kicks in. Does it become a right by default or does it start after the warranty period has expired? We need to explore this scenario as well. We suggest that India should, at the first level, adopt the French method and start rating devices on repairability. In my opinion, this rating can be like the BE ratings we have of 2-star, 3-star with respect to electricity usage that our devices take. Similar rating will enhance consumers' confidence in buying a product. They would know if it is easily repairable and related aspects. In the legal framework, we also need to consider granting exemptions to DRM. Now, most of the equipment these days is embedded with software, and DRM is not covered under fair use. This needs to be looked into. Secondly, we need to make sure that if a manufacturer is still breaking a product, that is rendering it unusable, if it is repaired through an unauthorized channel or through an independent repair shop, that needs to be penalized. The US also has a law in which the companies or manufacturer cannot condition their warranty on the basis of repair. India can consider having such a law. Fourthly, we need to encourage industry associations. In my research, I could only find an industry association with respect to automotive industry that was there in the repair sector. Similarly, we can have it in the consumer electronics and other industries that might be covered under right to repair framework. These stakeholders are very important in participation and making such a framework and raising their voice at the right level. Poland has interestingly given tax benefits to the repair sector. We can also think of something of that sort. Overall, if we legalize independent repair, that is functioning right now in violation of the intellectual property rights, most likely it will help formalize the economy, it will increase employment, and everything will be on the books. And this will, in fact, or if all these suggestions are considered, it will lay a solid background for the right to repair movement in India. We have said that the right to repair presently cannot be adjusted within the statute because it is beyond the definition of unfair trade practice as it exists. We have considered framing it under the rules if the government can frame it under the rules, but the major drawback is that the rules have to be within the wires of the statute. And if you want to amend intellectual property rights through a rule that is made under the Consumer Protection Act, that will be problematic. In our opinion, a statute or an amendment in the Consumer Protection Act is the best way going forward. Of course, it will take some time, but it will be the most solid option and also be a futuristic path, because we don't need to identify every sector that needs to be covered in the right to repair for eternity. Through the amendment in the act or a new act, we can put these powers in the rule-making powers, and the government can identify sectors that can come. For example, there was a lot of debate about the ability to repair medical equipment during the pandemic, especially in the United States. The hospitals were unable to get their devices repaired because the companies were taking it will take 3 weeks, 4 weeks, whereas those devices were urgently required. So over a period of time, we can guess, or we can take a call as to what categories need to be covered within the right to repair framework. Overall, the committee is in the best position to hold widespread consultations, consider every scenario, study jurisdictions abroad, and then come up with the right to repair framework as required under the Indian conditions. Thank you.
Thank you, Mr. Gaurav, for that wonderful presentation. If any of the judges have to ask or clarify some.
Gaurav, thank you for presenting on a good topic. Now, my concern is with regard to, as you mentioned, the intellectual property is concerned, because there are a lot of chances of the duplicating the products that's available in the market. If you look at the Indian market, we have a lot of Chinese products coming in, which is in as duplicators, and there is no guarantee for this. It could also damage the product which you have been using it for a longer time. So there's a chance of that. So don't you think that giving this right to repair will affect the complete market strategy of this particular perspective?
In fact, I think that presently, because if there exists no right to repair framework, independent repair shops are getting these fake parts that are used to repair devices. This, in fact, adds to the risk to the devices we use. If we formalize this framework and the original equipment manufacturers are ready to share the tools and the parts and the information that is required through an official channel, through a legalized channel, it will help the right to repair situation in India, and consumers would get added safety, and even the buyers, the independent repair shops, will have a surety that they're buying the genuine product, and this will lead to formalization of business, whereas it is very ad hoc and very jugaad type in the present date, in my opinion. Thank you.
But for me, the concern comes in again with regard to the now if you look into right to repair and right to choose, right? They are two rights which has a correlation also. Now I have a right to choose on what kind of product, who should repair my product, right? So how will you adjust with that? So like we have already a choice, right to choose as a right being recognized on the consumer. So why do we require to have a right to repair? How will you correlate those things?
So because even if you have the right to choose right now, chances are if you take a four-year-old mobile phone to a repair shop, they will say that it's no longer being manufactured and we don't have the parts to it. In our paper, amongst the things we have discussed, we have also just suggested that there should be a timeline as to which a part's life should be assessed. Let's say a mobile phone should work for at least 7 years. So therefore, for 7 years, its parts should be made available. So therefore, this formalization will help the consumer in the right to choose as well as to what products they are buying and also where they are getting it repaired from. And it's a genuine repair and not through a cannibalization method, which might not be most effective.
Okay, Gaurav, thank you.
Thank you so much.
Thanks for the presentation, Gaurav. You mentioned regarding fair and reasonable terms that you intend to talk about with respect to right to repair. I want to know what are those fair and reasonable terms?
Ma'am, as such, we have not explained that in our article. It is just
Yeah.
a suggestion, but this will obviously depend upon what type of sector we are talking about. This involves a lot of economic aspects and a lot of research and development that had gone into making of that product. And primarily, or like top of my head, I could think of the FRAN terms that are there in the patent law. But to be honest, I have not explained this in detail and neither examined this in detail in my paper. It's just a cursory suggestion which can be looked into.
Yeah, that's why I just felt that just to make it explicit. The second thing I want to know is you spoke about the French model and adopting a French model, etc., which talks about rating products on repairability. To what extent it is feasible given the wide range of products that we have? And are you looking at sector specific? I don't know. How it is going to be done?
Ma'am, when we see of an indexing model, obviously the consumers also have an idea that they have to look at it from a sector to sector point of view. For example, you might find 5-star air conditioners, but not 5-star water geysers. Just for an example, this might or might not be true. Similarly, when we consider with respect to consumer electronics or let's say farming equipment, consumers will get an overall idea as to the ratings within that sector as to how much repairable it is. And it is something which needs to come from the industry itself. Obviously, a government entity cannot have an idea how repairable a product is. So through self-disclosure and self-regulation, that index model can be evolved and it will benefit the consumers as they would know how repairable the product they want to buy is.
Okay, thank you.
Thank you so much.
I hope no further questions are left. So I would be moving forward to the next presentation. I think Sashikant sir is having some kind of problem. So we would be moving forward to Mr. Chandrasekhar and Ms. Aishwarya ma'am on repair or replace electronic equipment, the consumer's dilemma and the seller's leverage. If you are ready, please start your presentation. Thank you so much.
Good afternoon to everyone. I hope that I'm audible and I'm visible on the video. So the topic that we'll be dealing with is repair or replace of the electronic equipment and the consumer's dilemma and the seller's leverage. First of all, I wanted to say that the right to repair movement all across the world came into notice with the increased consumer frustration over the hefty sum of money they will have to spend with regard to buying new products which they are unable to repair, and the need of the lack of e-waste mechanisms due to the number of electronic products that are being used. So right to repair as a whole is a right to repair. If it can be defined, it can be said that it is the right of the consumer to repair the good to the extent of it being reused, and in furtherance to get a right in order to get about the information and information about the necessary spare parts, as well as the informations that can help them with respect to repair. And in this paper we have confined our sector to electronic equipment, since we felt that it is the digital era. In this digital era, the influence of the electronic equipment is beyond dispute. So I don't think we need to elucidate on that point of electronic equipment, because we are speaking in a virtual conference and the requirement of electronic equipment is needed in this time. Moving on to the next part, which is the movement of, or the evolution of the right to repair movement. The right to repair movement started in US in the form of lemon laws, where in which the automobiles, the right to repair for the automobiles were provided in the form of Federal Mechanism Warranty Act in 1970s, and later it was adopted. Several lemon laws with regard to repair of automobiles were adopted by UK, Australia, Canada, etc. And it has evolved to the present in the state that most of the countries, including US, UK, Australia, and every country has adopted a motor repair laws, and now they are most of the countries are doing feasibility studies with regard to the right to repair of the electronic equipments. And the countries like US and all, in certain countries there have been even suggestions, and in Australia, Productivity Commission has looked into the scope of the right to repair. And in India, if we look, we can see that a committee has been formed by the Department of Consumer Affairs, and in France, the French Repairability Index, as discussed earlier. And in regard to the future, we believe that we believe that there will be a formal recognition of the inherent right. Till now, we know that though the right to repair is an inherent right, in future there will be a formal recognition of this inherent right to repair. And one of the examples we can state is in US, wherein the Federal Trade Commission has said that they are planning to initiate a they are planning to add the repair restrictions along with the energy regulation rules, like the stars, the energy regulation, like with the stars, which has to be provided with the products itself, the electronic equipments itself. Now moving on to the next part, which is the bona fide or mala fide case of the display seller. So one of the most challenges with the right to repair is the part of the display sellers. The sellers who always the sellers are against the right to repair due to the express reason that it will lead to a reduction in the produce on this demand for the new products that they are producing. So the biggest argument they take is with regard to the IP law, which they say that it will lead to copyright infringement and trademark violations and all. But it has to be understood that the IP laws have been set up with the intention of balancing the interest of the author and the user, and it has not been used for the monopolization of the rights of a certain party. And IP law has to be understood from that perspective as well. It has the case of the defense of the sellers should always also be looked into from other perspectives with regard to like jurisprudential aspect, in which we can understand that if we look into a product in jurisprudential matter, the product, the owner of the consumer being the owner of is the owner of the product, and is not a licensee of the product as such. And in looking into the competition law, the competition law has in many countries found out that the reduction or the restriction on the part of independent sellers or independent repairers to sell the repair parts, or even the self-repair by the consumers, which are restricted by the companies, are found to be anti-competitive, and the competition law has looked into it. Now, with regard to the environment law, we have to say that the tsunami of the e-waste is currently going on in the world, and it is coming. It has to be also looked into with the fact that countries like African countries like Nigeria, where most of these e-waste are being dumped, and it can be seen as the remnants of the old colonialism that is going on in the world. And there is a requirement, there's a imminent need to find out the need of the requirement. So right to repair can serve as as a feasible option to protect even the environment and the accumulating e-waste. I'm moving on to the next part, which is India's right to repair, which is the baby step or giant leap. So the Consumer Protection Act 2009 states the right to be assured section 293 states that the right to be assured to the consumers. And as per this right to be assured, it can be said that the consumers has the right to be assured of the products available, goods or services available in the market at competitive prices. But if there is a restriction on the spare parts or the repair related informations, their right to be assured to get the services at a competitive prices are being violated. And with regard to the legislature, the role has been limited. And in the case of Shamsur Kataria versus Honda City, the Consumer Competition Commission of India has said that any restriction on the part or the spare parts by the independent spare parts or the repair related informations in automobile industries by the original equipment manufacturers to the independent retailers is not only a violation to the right to trade of independent sellers and independent repairers, but rather it is a violation of the consumer welfare who has a right to enjoy his product to the fullest. And further, the Department of Consumer Affairs recently only constituted a committee to analyze the scope of the right to repair. And as per the keynote address said by Nidha ma'am in the before session, she said that they have come to a consensus with the ministry as well as the various stakeholders have come to a consensus, which is a heartening news to hear. Now I'll be moving to the next part, which will be anything beyond repair. Here we'll be looking into some of the major plausible options which can be adopted in India. First is French Repairability Index. French Repairability Index is a case in which the manufacturers themselves are being asked to repair the to rate the products based on the repairability. As shown below in the picture, it is the repairability. The 1 to 10, there's an index being given, and 10 being the highest, it is the most repairable product. And we have stated in the slide the various criteria for saying about the French Repairability Index. So the main thing with regard to French Repairability Index, that it can create a responsible consumerism all over the world. So when there's a French repairability, when there's a repairability index, and when a consumer chooses the product, the onus will be on him so that he can choose a product which can be repaired, and he has to show the responsible consumerism by being an ethical practice of choosing the products which can be repairable. And also with regard to it is not saying that a French Repairability Index is mere is a foolproof thing, but a recent study by an NGO in the France stated that the French Repairability Index has achieved great results in improving the ethical consumer as well as the business practices. But still the transparency with regard to the rating of the products is still under question. Next, I'm thinking about the shelf life declaration. Under the shelf life declaration, the consumer is given when he is buying a product, he is given an option. He's given a guarantee by the equipment owner that assuming that the duty of care of the consumer is there, the electronic equipment that is being sold to the consumer will remain operative or will remain without defect for a particular period of time. And it is a declaration that the product, if it is destroyed within or it has a defect within the period of the shelf life declaration, then they will be liable to be repaired or even replaced. So some other areas which is anything beyond repair are the government incentives. The government should look into government should incentivize the people who are ready, that is the original equipment manufacturers who are ready to make consumer friendly and environmentally benign products, and they should incentivize the responsible consumers as well, and the industrial agreements between the original equipment manufacturers so as to ensure that the consumers will produce only consumer friendly and environmental benign products is also can be practiced. The Mendel schema anything beyond repair, we can say that both the parties, that is the consumer and the manufacturer, the schema, the Mendel the attitude should have a change. The consumer should buy the products which are object to use it till the last, and the manufacturers on the other hand, they should produce the products with a build to last attitude. So if the Mendel schema is changed, it will be great beneficial to the right to repair movement. And also the repair cafes in Australia and the International Repair Foundation and also the international organizations like iFixit, they have been contributing. Those kinds of organizations also contribute to the right to repair movement. Now moving on to the last part, that is the conclusion. What we would like to conclude with the paper is that right to repair is not a movement that should be initiated by the government or one party. Rather, it should be a cohesive and a movement which should be unitedly done by the state, seller, and the consumer, where each has to play their parts. The sellers should understand that they should follow the ethical practices, so that the products, they should not practice the planned obsolescence, and they should understand that in this growing era, in the growing digital era, the consumers are aware about their rights and the right to repair, etc. And if they are able to come into the market the products which has particular repair or other as such, then if they are able to promote the right to repair, then it will only satisfy the consumer and it will lead to increased business returns. So then the movement of the part of the consumer is that they have a duty of care to the product, and if they are being able to get the legalized product in a competitive price through independent cafes or even self repair from the sellers, they should have the duty of care, and they should then will be having an ethical duty to discourage the counterfeit goods. So anything against the counterfeit or the goods will be also can be set out by the consumers themselves. So the states, being the arbiter of the disputes, what they can do is they can create a balance of interest by using the carrot and stick rules instead of command and control, by balancing the interest of all the parties. And they should not just take the side of one party, or like they take the side of the consumers and they crucify the sellers. Rather, it should be done in the carrot and stick rules, where everybody gets a win-win situation and everybody is a happy person. So but on the other hand, they should ensure that the violators or any people who conduct ethical or moral or legal violation should be definitely fined. So that's the presentation. Thank you.
So if the judges want to ask any question, please go ahead.
Okay, Chandrasekhar, I have a question to ask. Now, you spoke about the ethical practices of the seller. Now, could you please explain what are those?
The ethical practices, ma'am, thank you for the question. So the ethical practices of the sellers would mean that they should produce the products with not with an attitude that it will die away, or they should not plan to destroy the products. They should ensure that when they build a product or they manufacture a product, it should be made built to last. They should have an attitude of making it built to last. So these are the practices that they should follow.
Does it also include that the product should last for a few years? And let's say a phone, they come up with new version of the phone, and whether that part is included under ethical practice. Are there any code, or are there any norms regarding that?
Ma'am, we have not examined that part, whether with regard to the new products. But ma'am, with regard to the entry of new updates or new products, what we have to highlight is that new products or new innovations may come, ma'am, but it should not serve as a hamper to the reduction of the right of the. It should not mean that the manufacturers should try to do practices that will reduce the quality of the products consumers have purchased before. So as a whole, if there's a code and all, it has not been examined. To our research, we have not been able to find such a code which stated that they have to follow ethical practices.
So what I'm asking is, let us say a new version of phone is produced by a seller, and the previous version does not support few applications. Whether that is part of the ethical practices?
No, ma'am. Like if they are producing a new innovative method or a new innovative phone with new methods or updated versions, it is not against the right to repair. But it should not. But the new phone should not be produced. When the new phone should not be produced, it should not be with the object that the older phone should go out of the market. If the consumer he is willing to buy the new phone or the new updated version, he has the right to buy it. But that does not mean that he should be exploited by making a phone which is supposed to die in a few years or just before the new phone is introduced. So as a whole, what we want to say is that yes, the consumer has the right to choose, and consumer has the right to choose a new updated version, but that it does not come at the cost of having a planned obsolescence on its previous product.
Okay, thank you.
Yeah, Chandrasekhar, now I have a question with regard to the e-waste and the right to repair. So you related both the things. Can you just explain what you meant by that?
So with the with the COVID era, we can see that the demand of the electronic products have plummeted, and if the manufacturers who produce these new products and who put them to the market, if they make the products, if the sellers make the products with the object or with the object that it should be die within a few years, and it should not be, it does not have the scope of being repaired, then the consumers won't have an option rather than to go and get a new phone. So if that is continued, the more and more electronic waste get accumulated. So, but in the case, if there is the right to repair is being promoted, and if the right to repair has a scope, then the existing the existing electronic equipment with the consumers can be repaired, and it can serve as a kind of feasible solution to control the e-waste.
No, but with regard to the medical products are concerned, so in there you have a lot of rights of the person who manufacture the product is there. So how will this, don't you think this right to repair will infringe their rights with regard to that?
Like, it should be understood, sir. They have the right to create new products and bring innovations. But as I mentioned earlier, it should not be at the cost of supplying to the consumers a product that will automatically die away or with the planned obsolescence. That is another unfair trade practice on their part. Yes, they have a right to give new innovations, or they have a right to produce new product, but it should be it should be kept in mind that the consumers who have purchased their product previously also has the right to repair. So any of their right which should be subject to the consumer rights, and they have, if they are able to produce a new product, and if the consumer wants that, then yes, then they have the right to, both the consumer has the right to purchase that new product. But it should not be done just because the consumer were not able to repair the previous product.
Okay, Chandrasekhar, thank you.
I think we have gotten over with the second presentation right now. So moving forward, I hope Sashikant sir's net is proper now, so we will be moving on with him. So I would like to welcome Mr. Sashikant Gaurav, to present paper on e-waste and right to repair, a step forward towards sustainable consumerism.
Good afternoon, everyone. I hope I'm audible to everyone.
Yes, you are. Please carry.
Thank you, Satyarth. Now, good afternoon, everyone again. Today, I'm presenting on e-waste and right to repair, a step towards sustainable consumerism. Now, before going to talk about my paper, I would just like to talk about that why did I choose this particular topic. As in the previous session, Nidhi Khare ma'am said that she and her team, they have nothing to do with the environment protection thing. Mainly, they are concerned with the consumer's right. But it's like a buy one get one free thing for us when we are dealing with one particular facets of law, where we are just dealing with how to protect a consumer right, and it is ultimately also resulting in the sustainable consumerism as a whole. For example, if we talk about today's era, we are continuously viewing or seeing technological development and so-called technological convergence. There used to be a time where we used to have different devices for different sort of works. Nowadays, what is happening because of this technological convergence, the number of devices which we used to use earlier for different purposes, all of them, they are being launched as a one single product. Now, whenever the technological companies, when they launch such products, what happens, they speak very highly of those products, that the most important feature of these products will be that they will be making one's life very easier. Now, wrong, but with this technological convergence and with this technological development also comes a market and economic uncertainty where we are left with a lot of e-waste. If I talk about the data of e-waste of India, the data provided by Central Pollution Control Board, it has said that in 2017 and 18, we had 7,08,455 tons of e-waste. Next year, in 2018-19, the e-waste data was 7,71,215 tons. Next year, it increased by 32%, and the amount of e-waste produced by our country, India, it was 10,14,961 tons. Now we can see that the amount of e-waste we are generating every year in our country. Now, the question comes that what's the reason behind it? That what's the thing is in e-waste of our country? Now, every time, just before, I guess, 1 or 2 months, there was Flipkart Big Billion Day sale. And then there are different festive season sale, which talks about new product, or we can get new product with exchange, or we can buy the new product without any sort of exchange. Now, the offers, they are so much luring that most of us, despite of the fact that we already have that particular device, we want to get the latest version. So if we look at this this chain of getting a new device, what happens because of some sort of technological development, there is a new device launched in the society, then they promised us some new design, some new technology, which creates a sort of sensation among the consumers. Now, as a consumer, what we do, we try to purchase the latest device which is available to us in the market. Again, despite of purchasing how much costly phones or any other devices, be it television, be it any sort of laptops, be it any accessories to mobiles or computers, be it any appliances like fridges, washing machines, or any household electronic appliances, no matter how costly we are purchasing, after 6 months or a year, there will be a new version of that particular device in the market, promising us to make our life more easier. Now, what happens that we always try to buy the latest product in the market, and as a result, we give a lot of e-waste to our society. Now, there are provisions, there are legislation which talks about disposal of the waste in India, but unfortunately, most of them, they are not followed. Now, to understand this concept, this problem regarding e-waste in India, while I was writing my paper, I conducted a random sample, and I tried to target the audiences of students who are basically students from the different law schools, and I tried to find out what their understanding is regarding the e-waste which is existing in our country. Now, the very first question which I put in that random sampling in that survey was that what is their knowledge of e-waste, and if they consider that this e-waste is any less harmful than other solid waste which is generated in our household or in our society. Now, most of them, since they were law students, they were aware that there is a thing like e-waste, but is it more harmful than the other solid waste which we are generating? So it was the most of around 58% of they replied that they acknowledge what e-waste is, but they're not very sure that how these are harmful. Then I have also targeted audiences who are working, and the question was regarding that whether their workplace had any e-waste management or collection policies. The answer was very likely just 10% of them agreed that yes, their workplace is having some sort of e-waste management policy, and still they are not that effective. The next question which I asked was that the consumer's personal e-devices, importantly phones, home appliances. Now, the question was that how many appliances do they have in their household? Most of them, they were having all those appliances which we consider to be of our necessity today. For example, fridge, washing machine, air conditioner, appliances like vacuum cleaner, food processors. Now, as per that survey, the number of users using the phone and the large appliances, they were very commonly available. But however, the number of mobile phone users, this was not restricted to one at a time. There are people among us also, there might be people sitting in this conference only who knows or who are having more than one mobile phone. They are using more than one mobile phones. Now, once I established that the mobile phones are the most widely used and the most frequently purchased electronic device, the last question was that what is the reason behind changing mobile phones or behind frequent changes of mobile phones? And majority of them, they replied with a common answer that because of the lack of phone repair or because of the lack of upgrade available. They explain that no matter whatever phone they get of whichsoever brand they are purchasing or how costly they are purchasing, it starts showing some sort of dysfunction or issues for like hanging or battery backup or capacity issues after 2 to 3 years max. And then they are not left with any other option than buying a new one. So we reached to a conclusion that sorry. So we reached to a conclusion that why the right to repair should be recognized today as an important consumer right. Now, if I talk about right to repair, now what's happening when we pay? For example, suppose I buy a phone worth 30 to 40K. Now I have paid a handsome amount for that mobile phone and I have received absolute ownership of that mobile phone. But because of the different copyright acts, patent acts, I don't have the right to modify, I don't have the right of customization in those mobile phones. As the previous speaker, the first presenter, he also talks about that if we are buying, suppose, a phone of Apple and there is some skin problem, we need to get it corrected from the authorized dealers only, authorized service centers only. We cannot do it, we cannot get it done from some local vendors. There is a planned obsolescence which is being followed by the companies, by the different technological companies. It's a very strategic act. If we talk about that, whether it is lawful or unlawful, obviously it is lawful. But when we talk about whether it is morally correct, no, it's a strategic act. Someone sitting in some Silicon Valley and they are deciding that for how long this particular electronic device is going to work. Now, no matter how costly things you are purchasing, because of that planned obsolescence of the manufacturers, you are forced to buy new product after a reasonable amount of time. Now, if we talk about right to repair legislations in India, so in India, it is still in the nascent stage, and then this committee was formed this year only, which is headed by Nidhi Khare ma'am, and then also Professor G.S. Vajpayee sir is a member, Professor Ashok Patil sir is a member in that. But there is a lot of things which we need to do before, or there are a lot of issues which needs to be entertained, which needs to be considered pertaining to this right to repair. Now, there are Copyrights Act, there are specific and exclusive right granted to the owner of any, or granted to the manufacturer of any particular product. Now, in the process of accommodating the repair, those patent laws, they do not provide certain avenues to the manufacturers of the products, but there are a lot of contradictions that infringes the right of one or other at the same point of time. Now, apart from Copyright and Patents Act, there are also trademark implications, such as in the due process of repair, trademarks must have been overused, infringing the right vested in the trademark holder. Then, if we try to connect this right to repair with sustainable consumerism, we need to understand what sustainable consumerism is. Now, different members of society or different societies, different countries, they may have different notion for this sustainable consumerism. There are countries who are developed, who have already created their impact, or who have already affected their ecosystem. Then there are countries who are still developing. Now, if we make the same bar for both these societies, that they should be having sustainable consumerism, or they should be having sustainable way of doing any development, it won't be justice to those countries who are still developing. Now, if we talk about this sustainable consumerism in India, so if we try to understand this concept, India as a country, it has faced great demographic and economic transition throughout 20th century, and it is still in the process of so many changes, such as population growth. There are very high fluctuations in employment and economy. There are continuous development in education, changes in infrastructure. There are and all these things, it is creating a heavy duty, a heavy toll and on natural resources. Now, every now and then we have so many major environmental changes happening all over the world, such as climate change, waste management, issues related to technological convergence, then overpopulation, air quality. So bringing in policy changes in order to address any such concern which is related to people at large, it exists at a point of time. And if I try to give, or if I try to suggest certain recommendations that what we can do uh, in order to implement this right of repairs, and how this is going to affect, or how this is going to promote sustainable consumerism in our country. The first thing is recognizing right to repair as a strong consumer right. Now, when we talk about right to repair, or now famously known as RTR, as a strong consumer right, the reason why it should be is that everyone who goes to the market, or who buys himself or herself any electronic device, be of whatsoever amount, he is a consumer for that particular purpose of this market. And now, once he has paid for the device, he should be given the right to repair, that too at a viable cost. Most of the electronic appliances, we can get it repaired, but the cost is so high that every one of us prefer to buy the newer one. Then there should be strong rules made against planned obsolescence. Right now, planned obsolescence, that's not an unethical thing. Even if we call it morally unethical, it's not unlawful thing. So if any electronic product which a customer is paying a large sum of money, a large chunk of money, that product should have a scope of getting repaired, getting updated, and the lifespan of that particular device must be more longer than what we are facing now. Then our government, it should make it mandate for every organization where a lot of electronical equipments are used to have e-waste management policies. Now, even if we don't come from IT sector, even if we're coming from academics, there are a lot of, more than, I guess, 200 laptops or computers in every colleges. Now, despite of the number of the very high number of electronic appliances or electronic devices in academic institutions also, there is no as such e-waste management policy. Then the next suggestion, or the next more and more service centers, because that's the first thing, or to make his mind in buying any product. For example, if I talk about just
Shashikant, sorry to interrupt, your time is up, so you'll have to conclude now.
Sorry, just okay, fine. Just on a concluding note, I would just like to say that right to repair, it is right now, it is not a right which we are having here, and the government should recognize this, and it should be provided to every consumer. And this planned obsolescence, this is a forced financial crisis which needs to be stopped on the part of the government. Thank you.
Yeah, Shashikant, it was a lengthy presentation. It was good, but I have a doubt or clarification that you need to address on. See, now, all that you have been mentioning is with regard to the e-waste generations and other things, but don't you think that there's some point of time that there is a perspective of innovation that happens, upgradations happening, and you say that these upgradations are causing all these issues. And where do you pitch in the right to innovation and the right to repair as a conflict?
So when we talk about this continuous technological development, it's not that every technological development or every new device which is bought in the market, they are in a very, there are a lot of differences to the previous devices. But the kind of marketing they use, the kind of luring promises they make to the consumer, this forces us as a consumer to get that latest product, despite of the fact that we already have a product similar to that. Now, this right to repair, I'm not against any right of innovation, but what I am contending is that this right of innovations should not be coming at a cost of consumers. Basically, this should not be coming at the cost of consumers' interest, and this should not be coming at the cost of society.
No, but innovations in the technology for medical equipments is a fast growing thing, because you know that every day now you need to upgrade when it comes to the healthcare industry is concerned. So in their perspective, if you analyze, there is a chance, or there is a that you may be infringing many of the rights with regard to that. Because I mean, if you say that the innovations or the right to repair should be made available to everybody who is generally knowing about the product, will definitely affect the technological perspective in the healthcare. So, I mean, don't you think there has to be a clarification on that particular perspective?
So when we talk about right to repair, obviously it is in the interest of the consumer, and it's the law of the nature that someone gains it, someone lost. But when we talk about the medical field or medical side, that where there are certain innovations, and if they are providing this right to repair, or if they are revealing their own USP or their own secrets, the thing is we should be looking at these aspects for a better cause, for the greater cause. Now, when we talk about electronic appliances for a daily household things, or when we talk about appliances that are used in the medical fields, now the appliances which are used in the medical fields, obviously they are cut down, or the committee which is made for this purpose, they can make frameworks in such a way that if there are products which are made for a greater cause, they should not be, or they should remain untouched by this right to repair which we are going to provide to the consumers in India.
Thank you, Shashikant.
Thank you, sir.
Okay, Shashikant, I have a question. Now, have you looked at best practices with respect to management of e-waste?
Ma'am, best practices as in India or other countries?
In India or abroad?
Ma'am, when we talk about e-waste management in India, as such, there are, I have not dealt with those things in my paper, but as per my knowledge, there are not very good policies made on the basis of e-waste management. So right now, we as a country, we are, fighting at a just disposal of solid waste, which is generating out of our daily household things. At that front also, we don't have a good policy. Okay, we had a very habitual of saying thus dump of the solid waste which is coming out of our daily household at the outskirts of every city.
So you when say that there is absolutely no policy with respect to e-waste?
No, I don't say there is no policy. I talk about the implementation, that as such there is no proper implementation of any e-waste disposal policies in India.
Okay, thanks.
Thank you, ma'am.
Thank you, Shashikant, for that very interesting presentation. I think it is time to move on to our next presentation. That would be the last in the lot. I would like to invite Dr. Ashwini Dalal to come forth and present the paper on recognition of right to repair as consumer right, which is a step ahead for minimizing waste.
Yes.
Sure. Ready whenever you are. Mr. Shashikant, if you could please stop the screen share.
Am I audible?
Yes, Ashwini ma'am, you are audible. Would you
Yeah.
like to screen share?
Yeah, I don't have a PPT. I'll just give the oral presentation. Will it
Okay,
be okay?
that would be okay. I just have to stop this. Sachikant sir,
Yeah.
can you please, are you able to listen to me? Okay, sure. Thank you so much. Ma'am, please go on.
Yes. Thank you so much for giving me an opportunity to present on this wonderful conference. Good afternoon to all the honorable chairperson, sir and madam. My topic is the recognition of right to repair as a consumer rights is a step ahead for minimizing waste. As we all know, Indian sacred literature points out to the impermanence of all things and to renewal and change is a part of the natural order. But the very same text reinforce the idea that renewal and renovation should be attempted before discarding or rebuilding. There is one caption in Sanskrit, Jirnodhar, an undeniably Indian approach to conservation and reuse. As we all know, any product life cycle has four stages: introduction, growth, maturity, and decline. Yes, agree that this cycle has its own pace. But now, what the manufacturer are doing, they are having a trick of planned obsolescence, premature obsolescence. That is the concerning and alarming factor for the consumer point of view and the health of Mother Nature. Why consumers are praising the right to repair? This right to repair movement has taken a momentum across the globe. The earlier presenter and in the introductory session, the guest and keynote speaker have highlighted, right? I think there is a industrial revolution and the latter on the developing rat race. There is a lot of mushrooming growth of industries. It is good. Industries has to be actually evolve, new innovations has to be evolved, but this mushrooming growth of industries without taking into consideration of the demand and supply ratio in the particular consumables, especially we are talking about the electronic, right? This consumables, there is a overflowed goods in the market on virtual e-com sites as well as physical market. There is two reasons I just have mentioned, that mass utilization of electronic goods, and almost every consumer product has some type of electronic chip and other technology embedded in it, and it makes difficult to repair it by use of the consumer by its own or third party without proper information and proper spare parts which is available in the secondary market by the original manufacturer, right? Due to this massive technological advancement, there is another issue of intellectual property, especially the patented product. And so the manufacturer has an attitude to tighten its control over the product, and he wanted to dominate in the primary as well as the secondary market. And so he restrict the aspect of repair issue. Now, as we all know, the LPG, due to the dawn of LPG, there is a mushroom growth of industry, and they have one motto only: mass production, multiple assets with a limited life of that particular product, and no scope of repair and reuse. Repairing attitude has been now unfashionable, right? And wiping out from the daily lifestyle of the person gradually. Bit by bit, develop a mindset of consumer that is use and throw noiselessly. And with this attitude or with this approach, we all are consumers, and we are all part and parcel of this destruction of the environmental heritage and push our mother or a dump yard. We all know, we have seen there is a centennial light, which is the world's longest lasting light bulb, burning since 1901. It was manufactured way back in the year 1890s. This 120-year technology manufactured goods having more durable and long lasting than as compared to the 21st century high-tech modern technique are unable to produce consumables. Or is it a conspiracy of short product life cycle? Yes, it is an open secret. And these manufacturers, what they do, they have on the caption of new features and in advanced version, the manufacturers are make the earlier version as outmoded and tempt the consumer to buy new one. Now this monopoly, this natural monopoly theory, which was actually propounded by eminent jurist Justice Richard Posner. And what he says that every potential manufacturer, because of the patent regime, intellectual property rights, so on and so forth. So every potential manufacturer of a unique goods and product would be vulnerable to litigation before the respective authority. And this would stem from the assumption that nearly every manufacturer of unique goods would be the market leader and own a major market share in aftermarkets for the said unique goods by supplying spare parts and repair services. So manufacturer controls over the primary as well as secondary market. That is the biggest issue we need to tackle on that. When we look at the e-waste generation, right? More than 50 million metric ton of e-waste generated globally every year, right? Shorter product life cycle have also made e-waste one of the fastest growing waste stream in the world. As we take a statistic, between the 2010 and 2019, e-waste generation increased by roughly 60%. And this growth shows no sign of slowing down. By 30, if we could see the scenario, by 2030, annual e-waste production is on track to reach a staggering 75 million metric ton. Global e-waste is thought to hold roughly $60 billion worth of raw material such as gold, silver, copper. And when we look at the recycling, only the 17% of the global e-waste is documented to be collected and properly recycled each year. What about the remaining waste? Where it goes? The fate of the remaining waste is mostly unknown, meaning huge amounts of valuable recoverable raw materials which are likely to be dumped and burned. Now, there is one positive news that the Competition Commission of India in 2014 in Shamsher Kataria versus Honda CL Cars Limited. In this case, it is a very good decision given by this. There were Honda plus 16 companies are on the respondent side, and they determine that exclusive access to spare part only to be authorized repairers of vehicle manufacturer amounted to anti-competition practice. The CCI mandated that the manufacturer needs to make spare parts available to all the repairers to promote healthy market competition. This is a welcome decision. And it is again a positive news that the government of India is going to legislate the Right to Repair Act. And yes, this if it is come into force, then the Right to Repair legislation, it's a game changer, I guess. And it's unlocked the door of sustainable development and open a vista of employment opportunities and minimization of e-waste. As we all know, it's a long battle between caveat emptor to caveat vendidator. Now we are marching towards the another movement, that is this in the Consumer Protection Act 2019, there is a concept of product liability of the manufacturer. But also now, if this R2R Act has been enacted, then there is a responsibility to share the user details, user and the detail about the how to repair the particular products with the consumers. As actually the Apple company, by providing the online repair shop, they have opened their online repairing shop, and so many more companies are actually following the path of Apple. So this is a positive, innovative aspect, and the giant company are bending before the consumers. Now, Indian government has actually taken a movement of lifestyle for environment, sustainable consumption. So to empower the consumer buyers in the local market, the purpose of this act that has to be going to achieve by enacting the act by the government of India, it again channelize the circular economy, then it harmonize the trade between the original equipment manufacturer and the third party buyers and sellers. Again, developing sustainable consumption of products and reduction of e-waste. That is and another positive aspect, because 1.3 billion population we have. And for that purpose, we need to, right now we are dependent on China and other manufacturing companies. But if this circular economy and this right to repair act has been enacted, it will be a really a game changer, and we can become a Atmanirbhar Bharat objective can be achieved in the years to come. Again, this act may break the culture of planned premature obsolescence, and to tackle the mammoth problem of the disposal of the electronic waste. As again a positive news that is published in the Land TSO on 30th September 2022, that India processed 73% of total waste generated in the financial year 2022. Fortunately, in our country, there is a vibrant repair service sector and third-party repairers. And if by enacting this act, we provide the spare parts and repair service center for boosting circular economy, and certainly it rotates the economic will of the nation. Now, earlier presenters have actually discussed about the European Commission. There is a United Kingdom have a law. United States also have a law. They are planning to enact the laws on the line of right to repair. I just wanted to make a mention here. This European Union has taken a very good step, and they come with a document, action plan document 2020, and they have precisely discussed the importance of the right to repair. And so all the other nations have followed that vision document, plan document. Now, as you all know, now we need more innovations and the R&D sector, like the US business tycoon Elon Musk has successfully invented reusable rocket launcher, which was next to impossible at the beginning. And this SpaceX company has successfully landed a rocket upright for the first time. This is a major milestone. So we need more such kind. India also needs such kind of business tycoon for doing such reusable product in the consumer and other areas. So I have given 3 suggestions. My first suggestion is, if we want to actually successfully enforce this right to repair law, we need a coordination between consumers, manufacturers, governments, and society. Without coordination between these stakeholders, we cannot achieve the objective of right to repair. Then, while concerning the consumer's right to repair, we equally need to strike a balance between the manufacturer right to sustainable business and the intellectual property rights attached to that product or service. We also need to inculcate the attitude among the consumers that say no to consumables harmful to the human environment through action-based education. It is not only theoretical, but it has to be inculcated through action-based education. Now, we have a tagline of Jago Grahak Jago. This tagline not suffice the purpose, but also we need to awaken the manufacturer on sustainability and their approach of multiplying the assets of plant premature obsolescence. We need a Jago Utpadak, Jago, because some or the other way, everyone is consumer, and such kind of generating e-waste ultimately harm the human civilization severely. So this is all. Thank you so much for giving me an opportunity. Thank you. Over to organizer. Hello.
Yes. If the judges have to ask something.
Oh, okay.
Yes. Thank you so much, ma'am.
Yeah, thank you.
Okay. So I have a question. So
Yes, ma'am.
So today we can say that consumerism is something which is the talk. So in light of consumerism, you talk about limiting the use of products. So how do you think that it can be made possible?
Actually, when we have given the right to choose, and that right to choose has been actually misspelled or misused both by manufacturer and consumer. Now we have, I'm not saying you have to control your purchasing and all, but we need, when we are actually when we are talking about the sustainable development, we need to have to, there is actually tendency among the consumers. They don't require the goods, but they have a habit of purchasing that goods. So whether we have a need and it's a greed, we need to actually identify between these two issues. Need is important, but when we are actually storing beyond our needs, then it will be a harmful not only for ourselves, but when we are talking about the society and the nature and the globe, that has to be, we need to actually focus on that point. It is the need of the hour. Otherwise, there will be a lot of problem which we or our next generation will certainly face.
So my question was, how will you bring about a normative framework for that?
We have to have a actually regarding the,
is it feasible or is it possible to come
yes,
up with
it is possible. Yes, it is possible by inculcating action-based education. We need to, it's a proper education that has to be given to the consumer, because there is no other answer. Except the proper right-based, action-based education.
Thanks.
And so we need to have to conduct such kind of codes, how to inculcate such thought among the young population.
Madam, I had a question with regard to the consumerism that you were speaking about. See, the complete market strategy or the complete economy is based on the product that is available in the market and the purchase of it, and the business sustains on the basis of that. Now,
yes,
you want, as my co-judge and the co-chairperson Sharda said about how will, I couldn't understand how are we going to base a balance between the both from the manufacturer's perspective as well as the consumer's perspective, because when it comes to products that has been made available in the market, the innovation that happens, which gives the one-way rights to the innovators. There is an economy that has been built up on the basis of that. There is a rights of many people who are working in this particular sector. Their rights are concerned. Absolutely. So everything has been involved in when you consider this particular idea of sustainable consumers. So how are we going to keep a balance so that it doesn't affect everybody's rights, but it also does not create a problem for everyone. So that part of balancing is what Ma'am was trying to put up before you.
Sir, actually, for balancing the manufacturers, right, the employability and overall economy. So we need to have a involve the stakeholders, all the manufacturer, consumers, and then we need to actually take out some viable solutions for both manufacturer as well as the consumers. Because it is actually at this point of time, it is very difficult to answer how we can actually, but we can answer, we can find the solution by deliberation and discussion with the manufacturer as well as the other stakeholders.
Thank you, ma'am.
Yeah, thank you, sir.
Thank you so much, ma'am, for that great presentation. I think I have learned way too practical knowledge from it. So I think we have completed almost all the presentations that were scheduled for now. We will be proceeding towards the question and answer round for now. So just for few modalities for it, how we would be proceeding on it would be, there would be an interaction between the judges and the participant, that is the presenters. If the judges have to ask anything, you can again ask them. If you think you have not been able to ask it during that time, and vice versa, even the presenters now could ask any feedback apart from feedback on their presentation. They could ask any general doubt from the judges, because we will have a feedback round towards the end of this session. After it is over, we'll open the floor for all the attendees here, so that they could ask questions from anyone, like from presenters or the judges itself. So we will be beginning now. You'll just have to raise your hand. There is a Zoom option coming down. So you'll just have to raise your hand, and I will be picking on you to just unmute yourself. There are no hands for now, so I will be waiting for like 10 more seconds for a judge presenter interaction. After that, we'll be proceeding to the open house. So at least from the presentation, I think there are no more questions left. We would be opening it up to the audience. If they have to ask anything from any of the presenters or any of the judges, they could just raise their hand, and we could proceed on with the question and answer round. Yes, Mr. Gaurav, please go ahead.
Sir. Rahma, I don't know if you got a chance to see the paper we have submitted, but from an academic paper point of view, would it have been better to focus on only a single aspect of the framework that I was proposing, or is this method of having a glance at everything and giving a comprehensive outlook was a better method to go about in the conference?
Gaurav, as far as the point that you have raised or your paper is with regard to when the area that you were concentrating on, it is totally up to you to research, present what you have researched upon on that perspective of the topic, rather than to going about to everything. But yeah, I really feel that this area is something which is coming up as a to be debated upon, because we do not have a policy onto it, and of course, and when it comes to India, there are a lot of things involved in coming out with a regulation, because I said, we have been told that there is always something called as an impact assessment of every regulation, and unfortunately, we not normally go into the impact assessment of a regulation to understand how this regulation is going to create the economical as well as the litigation or any perspective, any in that manner, if you realize any changes that is going to make in the society. So probably, I mean, I thought somebody would be looking into that portion also, because the consumer courts now, you will find that a lot of cases are increasing even in the consumer courts, which we have created to solve the issues with regard to consumer and I mean now this new regulation, right to repair, again you're opening up another branch of litigations to be coming out in this new right is also going to be a big issue, as well as I mean, when you say right to repair, I mean, I was just thinking, if my phone doesn't work, the first thing that I do is I go to a company sales center and I ask them that this is the issue. Now, we think that they are the best in the technology because they have been trained to understand what is the complete product is. So now, if you go to a third person and he tells us, I can do it in a very lesser price, and you make it the parts available to him, if he does something wrong with the product, then we have no other option to go to the product manufacturer and then ask him for the service. So we are actually trying to create more situations by recognizing such a right or not is one question that I had in my mind. I wanted to discuss when the floor was open. And there's also, as I said, I mean, my concern was one more thing of medical equipments, because I've been knowing very close friends of mine who are doctors who say that the technology in medical field is every day developing. So when you make it open to anybody to utilize the product that has been made available, so there is a lot of issues that's going to come up in this particular field also, because I don't know how, I mean, there has to be a feasibility study on this. So yeah, but you have definitely done a very good work in with regard to the paper is concerned. I mean, I appreciate that. A good comparative study was also done by you on the right to repair aspect is concerned.
Thank you, sir. Thank you for your inputs.
Okay, so you asked a question on the structure of the paper. So in this case, since there is no policy or guideline with respect to repair, I would say that going for a comparative study is something which a researcher will do, because to look at different models and how those models have worked and to emulate a successful model is the thing that we do. So I think as such, regarding the structure of the paper, I think that is perfectly fine. So
thank you.
Yeah.
So nobody has question even in the open house, I think. If they have, please raise your hand, or otherwise we could just go on to the feedback session. As you were just giving kind of feedback to Mr. Gaurav, you could just continue on it and just build upon it, and you could give a feedback to him on his paper itself.
Okay, we don't have papers in front of us. I think we have only abstracts in front of us. So whatever that I can, I have read all the abstracts. So whatever that I can gather from the abstract and from his presentation, I think Gaurav has done a good research, and his presentation was also good. Now I mean, the only question that I had after reading the abstract was which model he would suggest and why he would suggest a particular model, and which I think he has very well answered while doing his presentation. So that was with regard to Gaurav's presentation. Yeah. So should I give feedback on every candidate?
Yeah, Shahid, I can.
We'll have to do that. And if sir, if you have to add something based on abstract and presentation itself, not on the article, because it would be substantively reviewed. So that's a separate thing. Fine. Sir, if you have to add something.
No, fine. I mean, I've already told Gaurav what I wanted to. And it was a general concern that I had with almost all the speakers. See, many of the speakers, and I'm giving it in a general because I've written down certain points based on what the presentations were. One such point that I've looked upon is that we all discussed about right to repair and the perspectives of right to repair, but nobody has come out with a clear cut. Suppose I said Gaurav has made a comparative study about it, but he hasn't suggested that these should be the points that has to be specifically included in the right to repair regulation or a draft kind of a regulation which could be modeled out by any of the presenters so that could be considered and be taken up by the government or be sent to the government for the purpose of discussion. So one that particular aspect that I have looked into. Then second thing, as I already mentioned, the impact of the new right that is going to come up in the consumer law. That is one of the thing that or maybe the speakers might have looked into. And in the Shashikant's presentation, the innovation technology, that is a very good area that he has worked upon. But yeah, I couldn't mean obviously he has more dedicated slides on the e-waste management and other perspectives, which was one of the negative impact of not recognizing as a right. But what will happen how far it is going to create, or will this stop this particular perspective e-waste concept in India is what one thing we need to look into, because as I said, products change, new technologies, new products, new additions happens every day. And we as a consumer state, we actually consume. So will this, giving this right will stop the e-waste production in the country? That's a big question to be answered. So on that was also a question with regard to Ashwini ma'am. She spoke about the consumerism, sustainable, but as I put the question before her itself, that how will you draw a balance between all the perspectives of consumerism? These were my general observations with regard to the papers or concept.
Thank you so much, sir. I think that is helpful. If somebody has to ask or take a specific feedback, they'll raise their hand, hopefully. Sharda ma'am, if you have something to add on to general feedback or specific feedback for that purpose.
Yeah, I think two of the presenters spoke about e-waste management. So I would have loved to listen from them. What is the policy and what is lacking in the policy in India, and what is a way forward for e-waste management? So that is something which I was looking for when I heard of e-waste management, etc. And what can be done, or researchers could have looked at the best practices elsewhere and presented those. So that was the thing that was in my mind. Yeah, that's it.
Thank you so much, ma'am. And if the four presenters, if they have something to ask related to like their presentation, they could. I will wait for like 10 seconds. If they have something to ask, raise your hand. Just think about it, like 10-15 seconds.
Yeah, Satyarth, I have one doubt in my mind.
Sure, ma'am. Go ahead.
Yes, I just wanted to both the chairperson sir has put a question how to strike a balance between the present the demand and supply. So, sir, how we can actually find out the solution for that problem actually?
Madam, that is what I was looking out into your paper, because when we try to analyze a situation and to find out a solution for a particular problem, sustainability. That's what I want to write, especially put out that how will we strike a balance between when we give a particular right? How will we strike a balance between many rights when we open out a regulation which curtails somebody else's right? That has to be discussed out in the regulation very clear cut. Otherwise, it's very difficult for the regulation to be successful when it comes to implementation part is concerned. That is why I said we have to do a thorough study on the subject when you plan to do such kind of a change or modification with data regulations. So when you said sustainable consumerism, how will we come out with a model policy of a sustainable consumerism is concerned? And who are the stakeholders in who are going to be affected if we come out with a sustainable consumerism model? So that has to be clearly demarcated and studied upon when you come out with any kind of a new legislation or a new policy or a new document where you are trying to regulate certain things in that. That's what my question was to you, because I mean, that is what the complete research is all about. Where we stand. I mean, how will you explain the complete concept of it? That's what I think Sharda also asked the same question, if I'm not wrong, regarding the consumerism is concerned.
Yes. But the answer, on my perspective, the answer is right education, sir. Because we have to empower the consumer itself.
Exactly.
And then only when the consumer denies to buy the goods which are harmful for the nature, for the sustainable development, then and then only we can, to some extent, we can achieve. Because
I agree to. Sorry, but I agree to that particular point. We agree that the consumer education is something which is more required in a country like us, where we are a consumer state, or we consume more. But I mean, yeah. But how will you implement it is a big issue. As you said, Jago Grahak Jago or Jaho Utpadak Jago, all these are the coin terms that happens only within the four walls of certain areas. It doesn't go out of that.
Right. Thank you, sir.
Thank you so much, ma'am, for that question, and thank you so much, sir and Sharda, ma'am, for answering it so perfectly, as far as it was feasible. So I think no more questions or feedback is due now. If somebody still has any question, please raise it now. I think this is a good point where we could end this session with a vote of thanks. I would like to now invite Anshuman to just take the mic and give a vote of thanks to everyone.
Good evening, everyone. My name is Anshuman Kishore Mishra, and I am a third-year student at National Law School and a line editor in the International Journal for Consumer Law and Practice. So we witnessed the parallel session 3 on the recognition of right to repair as a consumer right and sustainable consumerism. So first of all, I would like to thank our chairpersons and judges, Professor Jijimon V.S. and Professor Sharda Sindhe, for their wonderful conduction of the entire session and their wonderful feedbacks and queries to the presenters. Then I would like to thank our presenters, Mr. Gaurav Pathak and his co-author Gaurangi Kapoor, who presented the article on suggested framework for the right to repair in India. Then I would like to thank Mr. Sashikant Sarov, who wrote and presented an article on titled E-Waste and Right to Repair, a Step Towards Sustainable Consumerism. Then I would like to thank Mr. Chandrasekhar V. Pillai and his co-author Aishwarya Lakshmi VM, who wrote and presented an article on repair or replace electronic equipment, the consumer's dilemma and the seller's leverage. And in the end, I would like to thank Dr. Ashwini Dalal, who wrote and presented the article on the article titled Recognition of Right to Repair as Consumer Right is a Step Ahead of Minimizing Waste. So all these presenters and authors very well summarize the point about how sustainable consumerism is the need of the hour, and how right to repair is very important, not only as a great tool for upliftment of consumer rights and the monetary benefit of consumers, but it is equally important to achieve the sustainable development goal in order to leave a better earth for our future generations. In the end, I would like to thank our moderator, Mr. Satya Srivastava, for facilitating this session. And once again, I thank all of you, all the attendees, all the presenters, and all the judges on the behalf of National Law School, Chair on Consumer Law and Practice, and International Journal for Consumer Law and Practice.
Thank you so much, Anshuman, for that rapid fire vote of thanks. So, no problem. But so first of all, I would like to thank again both sir and ma'am for attending this session and judging this round. And as for the presenters, you have done very well on all the fronts. Even if you cannot win, I just would like to mention that we still have a Scopus Index Consumer Law Journal, IG Silpi. You could send it there and we would happily review it and give you it, because you have already gotten the feedback. So you could, knowledge never goes to waste. So we'll anyways be happy to just go over it and give it a place in our journal. So I hope you would incorporate the recommendation, because you have learned as much as we have today. Thank you so much for attending this session and giving your valuable feedback, be it the judges or be it all the participants or the attendees, those who are present here. Thank you so much.
Thank you, Satyat, and thank you, Anshuman.
Thank you so much, sir. Thank you so much, ma'am. And thank you all the presenters. All the best.